just a bit about us to begin with. So my name's Alex, and I'm a UK chartered and EU trademark attorney in the Dehns Trademark Group, based in the Brighton office. And this is my colleague Adam.
Hi, I'm Adam Kellett, and I'm also a chartered UK and EU trademark attorney, and I work in the London office of Dehns.
So this webinar is designed to be an initial overview of trademark protection, and really the key issues and considerations to be taken into account when thinking about registering a trademark. So by the very nature of this webinar, we're going to be covering quite a few issues at a fairly introductory level, but please do let us know kind of either in the comments or by follow-up if a more in-depth session on a particular topic would be beneficial, because we'd be happy to tailor a future session to those requirements.
So we'll begin by outlining what a trademark is and how trademark protection is important for all businesses, from startups and sole traders all the way through to larger organisations and multinational corporations. We'll then discuss a number of relevant considerations when it comes to trademark protection, including what precisely is being protected, when you should look to obtain protection, and where in the world you should be trying to obtain a protection. Finally, we'll outline the process for obtaining registered trademark protection in the UK and the types of issues which might arise during that process. Please do feel free to use the Zoom Q&A box to raise any questions you may have, and we'll answer these at the end of the webinar.
Okay, so to begin with, what is a trademark? So at the most general level, a trademark is a sign that is used to distinguish your product or service from those of other businesses. So for example, when you go into a supermarket, you might see a whole cabinet of bottled water. The product is fundamentally the same, but customers can differentiate between them and make their selection based on things such as the brand name, the logo, or even the overall get-up. So in this case, that might include the bottle shape, for example. Another way of thinking about a trademark is that they're relational. So what I mean by this is that they are kind of the main link between your business and consumers on the marketplace. So this is because, on the one hand, trademarks are really a form of marketing through which you can communicate your business and its values to potential consumers. And then on the other hand, they're also the primary means by which consumers can identify and remember your business, which facilitates that kind of all-important repeat custom. So trademarks are therefore central to every business's overall brand. They're essentially a means by which you can protect your investment in building your company's image. And so in this way, they really should always be taken into account during the sort of brand creation and marketing process. So though fundamentally, trademarks really are kind of a legal concept, but this doesn't mean that there's no room for creativity. In fact, there's actually quite a lot of room for flexibility in terms of, what aspects of branding can be protected. And this is because a trademark can take many forms. So most commonly, trademarks will consist of a word, such as a trading name or the name of the specific product or service, or a logo, or a combination of the two. So on this slide, we're taking a well-known example here, so Cadbury's. So the first mark on the slide is the plain word Cadbury. This is a word mark which corresponds to a trading name. Then beneath that, we've got the dairy milk. So again, this is a word mark, this time relating to a specific product. The third mark on the slide, the Cadbury logo, here we can see that this is a sort of a combination of a word and a logo, because the sort of word Cadbury is distinguishable within it, but it's in a sort of stylized form in comparison to the first mark. And then finally, we've got this milk logo as the final image on the slide. And we can see here that this consists of an image alone. So these types of trademarks are really kind of the sort of starting point. They're going to be important for any business, and they're typically the starting point of any sort of portfolio. That said, UK and EU trademark law does allow for the possibility that a trademark might have a less conventional form. And this can range from things such as slogans and the shape of a product to even kind of a sound or a particular colour combination. We can encounter difficulties here though, because unlike names and logos such as on this slide, which people are kind of used to relying on to identify a particular party's goods, Other types of signs can be trickier to register as trademarks because consumers are sort of less likely to associate them with one brand in particular. So turning back to Cadbury then, it has over the years sought to protect the shade of purple used on its packaging as a trademark. So the example that we've got on the slide here. And other chocolate manufacturers have actually tried to protect the shape of their products. So a notable example here is the shape of a Kit Kat, which you can also see on the slide. These applications have actually been the subject of sort of numerous legal cases across multiple jurisdictions. And this is because it's kind of considered that these signs, so a single colour or the shape of a chocolate bar, rarely deemed to be sort of unique to one business alone. So for example, you might go into a supermarket and see sort of own brand chocolates, which might have purple packaging or might take a similar shape to that of a Kit Kat. I mean, that said, despite these challenges, if you are successful in registering a more unusual sign or feature as a trademark, the potential value that can have for your business could be really quite significant because they're extremely memorable. And in some cases, they even become kind of an iconic symbol of a brand. So here we can look to the McDonald's "I'm Loving It" jingle, and also MGM's lion roar at the start of a film as being good examples of this. These are both protected as sound marks in the EU. So really we can see then that as well as being important from a legal and a commercial perspective, there's also plenty of scope to get creative with your trademarks, and you should be considering them at all times during your branding and marketing planning.
So why is it important to protect your trademarks? As touched on by Alex, your trademarks are what consumers use to identify and recognise you. So trademarks are therefore crucial in developing public familiarity with your brand and customer loyalty. It's therefore important to ensure that you can stop others using the same or a similar trademark in a way that could confuse consumers, divert business to a competitor, or damage your brand's image. For instance, if there are lots of other businesses using the same or similar trademarks in the same or similar fields, it might be difficult for consumers to reliably recognise and remember you and develop a relationship specifically with your brand. And even if there's just one other business using the same or a similar trademark in the same or a similar field, consumers could confuse the two of you and custom could end up being diverted to that competing business. Moreover, if such other businesses offer goods that are defective or of an inferior quality, and customers mistakenly think that those goods originated from you, then it could be the reputation of your brand that takes the hit. So registered trademark protection helps you to prevent or deal with these types of issues by giving you rights that you can enforce against third parties.
So building on the point that Adam just made, as a more practical point, registration is also important because generally speaking, UK trademark rights are granted on a first to file basis. So by this we mean that the party who successfully applies to register the mark first often has the upper hand. And really, so putting this into practice, this kind of means that if you avoid or delay securing trademark protection, your business could encounter problems further down the line if another party registers your trademark or a similar sign before you in your commercial field. It's not quite so clear cut as that because UK law does provide sort of some protection for unregistered trademarks that have been used for a number of years. But really registered protection is a lot more comprehensive as it offers nationwide exclusivity, whereas often use-based rights can be limited to a sort of specific geographical area where you've been trading. Similarly, if you need to enforce your rights against a third party, this is a lot simpler if you have a trademark registration, as opposed to just trying to rely on unregistered rights. This is because when you get a trademark registration, you get a piece of paper which says it exists, you get your registration certificate. There's a clear record of all trademarks registered in the UK, and this can be relied on to prove that your rights exist. Whereas if you want to rely on an unregistered trademark, you need to kind of gather and submit quite extensive evidence of use to sort of prove that your business has rights to that sign. I would mention at this point that owning a registered company name with Companies House or holding a domain name does not mean that you own the sign from a trademark law perspective. Company names and domain names, they're a related area, but they are distinct from trademark law. And so owning these will not entitle you to stop another party from using a sign which corresponds to either your domain or company name. Generally, these issues are going to be outside the scope of today's talk, but we would be happy to cover domain names in a separate webinar in the future if this would be of interest.
So aside from being useful in terms of protecting your business, trademark rights are also intangible assets that themselves add value to your business. They can be sold to other parties in exchange for money. They can be leveraged as security in business deals or for loans, and they can be licensed or franchised to other parties in exchange for royalties. So by registering your trademarks, you make a more solid claim to these intangible assets, and you enable yourself to commercially exploit them. Additionally, if you're a smaller company or a startup that potentially hopes to be acquired by a larger company down the line, or you're even just looking to gain investment, having proper trademark protection in place can make you a lot more attractive. This is because a lot of the value of your brand and your business is tied up with your trademarks, including your goodwill and your recognition among the public, and the selling power of your brand. A company looking to acquire investment in you is probably going to want to know that you'll be free to continue using those recognized trademarks, and that you can protect your brand against other companies. If you haven't protected your trademarks and checked that you're free to use them, you could look like a riskier investment, because there would be a risk that another business might obtain rights in a relevant mark before you, or might have already done so, in which case you might ultimately be forced to rebrand and have to put in a lot more effort and expense regaining the goodwill and reputation that you had before in your old trademark. So in summary, registered trademark protection can help you to protect your business interests and the valuable goodwill built up in your brand over time, as well as add value to your business.
So looking now in terms of what owning a registered trademark actually enables you to do. In the UK, if you have a trademark registration, you would be entitled to stop or prevent other individuals or companies from using in the course of trade or registering the same or a similar mark in respect of the same or similar goods or services, if consumers are likely to confuse the two marks. So this is quite wordy, but if we kind of unpick this, what it means is that if someone tries to sell goods in the UK under a sign which is similar to yours, or they apply for a trademark in respect of those goods, then even if those goods are not exactly the same as the goods which are protected by your trademark registration, you would still have grounds on which to prevent them from doing so. Similarly, the sign itself also doesn't need to be exactly the same. So putting this into context, in a recent trademark opposition in the UK, the owner of the earlier mark taqueria, which we can see on the slide here, was able to successfully oppose a later application for the mark taqueria for identical restaurant services. And this was mainly because these two signs sound really alike when they're spoken out loud. So even though these marks look quite different, obviously we've got one word compared with two words, and the different sort of letter string in the middle, so QUE compared with CO, because they're pronounced in a really similar way, then this can be enough to find them similar. I think it's an interesting point in this case actually was that one factor that was deemed to be important was that because the services were restaurants and consumers often tend to kind of recommend places to eat to one another during the course of a conversation, it was considered that actually how the marks sound when spoken aloud was really quite important. So really the main point that we want to make here is that the scope of protection that you get with a registered trademark is actually broader than the mark you use or the registration itself, since you're covered not only for identical, but also similar marks and similar goods and services. As a related point, I would also mention that if your mark is particularly well known, you can also stop others from using or registering a similar mark, even where the companies operate in really quite different commercial fields, because you can argue that such use might take unfair advantage of or tarnish your mark's reputation. So again, we've got even greater protection here for marks which have a reputation. But this isn't something we're going to go into detail on in today's session. But hopefully this has kind of provided you with some guidance as to why trademark protection is important. And so now we're going to look at more detail on some practical considerations, such as when, what, where, and how to get a trademark registration.
So starting with the when to get trademark protection, it's generally advisable to obtain trademark registration as early as possible. This is so you can try to avoid someone obtaining rights in a relevant mark before you do, be it intentionally or even just by chance. Trademark conflicts don't only happen when someone intentionally tries to rip off another business's brand or counterfeit or produce counterfeit products. A lot of trademark conflicts arise when companies just happen to have chosen similar trademarks. So by filing an application as soon as possible, you reduce the risk of someone else getting in there before you. However, before going ahead with using and registering a trademark, it's important to have searches conducted to check for any existing trademark rights that could block you from registering your trademark, and more importantly, that you might risk infringing if you use your trademark. From a pragmatic perspective, if you won't be able to use the mark because another business could sue you for trademark infringement, there's probably very little point wasting money trying to register it or building up a brand on that mark. So searches should ideally be conducted in all the countries in which you plan to use your mark. And searches typically focus on the trademark registers, and they look for identical or similar trademarks covering the same or similar goods and services. The cost of having searches conducted depends on the number of countries involved and how thorough the searches are. For example, you can have narrower initial searches conducted that look just for very, very closely identical or similar marks. They can be a lot cheaper than having broader searches that aim to be more comprehensive. And the costs also depend on how many classes of goods and services need to be checked. And Alex will explain a little bit about classes later on in the webinar. While searches incur costs at the outset, they do help you to reduce the risk of running into difficulties and more substantial costs later down the line. If you find out further down the line, once you've been using a mark, that you're actually infringing someone's trademark rights, this could cause you substantially more inconvenience and expense. For example, if you're sued for infringement and have to pay damages to the trademark owner, and if you're forced to rebrand, I mean, it can be very costly to go through a rebranding process, having to change your packaging materials, educate consumers about your new trademark, and ultimately regain under your new mark the same level of goodwill and recognition that you enjoyed before. So in summary, you should ideally only consider using and seeking to register a trademark once you've had searches conducted, but you should be looking to look at the trademark aspect of your branding as early as possible.
Okay, so once you've established that you are safe to use your trademark, then deciding what to protect kind of seems like the straightforward part. So you want to protect the trademark that you use. However, in reality, it can be slightly more complicated because obviously businesses often have sort of a number of signs or indications which would be suitable for trademark protection. And further, these can often appear in a variety of kind of colours, fonts or styles, sort of depending on where they're found. So for example, your trademark might appear quite differently on your website compared to on your business card or at the top of an invoice. And obviously it's not particularly practical to register each and every iteration of your trademark. And so it becomes necessary to consider which signs and also which versions of those signs should be the subject of register protection. Also, it's not possible to change or amend a trademark once it's been filed without submitting a brand new application. And so this is really something which should be thought about at an early stage. As trademark attorneys, this is something that we can help to guide you with. There's certain kind of considerations to be taken into account. And the three that we're going to talk about today, so the first is obviously budgetary constraints. So with each additional trademark application, costs will increase. And so it may be necessary to adopt a more focused filing approach, at least initially at the outset. So again, your trademark attorney would be able to advise you as to sort of possible workarounds so that you can get the protection you need on the budget that you have. So one possible strategy might be to register what we call a combination mark, which contains both your trading name and also a logo. This would obviously mean that you only sort of had to file one application as opposed to two, but this would need to be kind of balanced against the slightly weaker protection that this may offer compared to registering each element separately. So these are kind of the issues that need to be kind of assessed and weighed up before proceeding. Then secondly, it's also important to think about how you're going to use the trademark in practice. This is because once a trademark has been registered for 5 years, it's really important that you are still kind of using that mark and trading under that mark in order to maintain the validity of the registration. If you're not using a trademark after it's been registered for 5 years, then it can be cancelled by another party. So therefore, you need to think about the kind of possible implications that this might have on what you apply for. So in terms of perhaps like the colour or the font or the stylization that might be part of the trademark. Think about whether or not you're still going to be using the trademark in that way in 5 years' time. And then finally, this really links to the previous points, but also the importance of the trademark to your brand. As a general rule of thumb, it's always going to be more important to protect a permanent brand name than a more secondary trademark, such as a slogan, which might change over time. I think really kind of a good question to think about as a starting point is, how will your customers sort of mainly encounter and remember your brand? And having this question in mind might sort of help you focus on where you really want to prioritize.
And aside from considering the specific mark and format that you want to register it in, it's important to consider whether the mark is actually likely to obtain registration. One of the main requirements for a trademark to be registered is that it's capable of distinguishing your goods or services from those of other businesses. In other words, the mark needs to be something that consumers could rely on to identify you. This will not be the case if, for example, the mark describes the goods or services, or if it consists of fairly common promotional indications. And that's because consumers are likely to see a mark of that nature as describing or promoting the goods and services, rather than indicating the commercial origin. To give you some examples, the word chocolate is the name of a category of goods and a flavour. So it probably would not be seen as distinctive for chocolate bars or for food products that are flavoured with chocolate. And likewise, the word fresh would probably be seen as describing the freshness of food products, or perhaps the scent of cleaning products. A word like cheap is likely to be seen as describing the price of goods or services, and words like best are generally laudatory or promotional, and are likely to be seen as describing the quality of the goods and promoting the goods and services. The general reasoning behind prohibiting registration of marks like that is that it would be wrong to allow monopoly trademark rights over these types of indications, because other businesses might need or reasonably want to use those types of indications in a descriptive or generic way. Returning to Alex's earlier example of Cadbury, if Cadbury were granted a trademark registration for the word chocolate and could stop others using that word in relation to chocolate bars or chocolate flavoured goods, it would be very unfair and a big problem for competitors. In contrast, the name Google is a made-up word, so isn't innately descriptive of any particular goods or services, and therefore it's a distinctive trademark for the type of software goods and services that Google provides. As another example, the name Apple, although being an existing word in the English language, has no meaning in relation to computers or phones. So these are therefore examples of trademarks that are inherently distinctive and registrable for the relevant goods and services that their owners provide. So while the general position is that descriptive or non-distinctive trademarks can't be registered, it might be possible to obtain registration of a mark like that if you've used it for a number of years. And if you're able to prove that consumers have come to perceive that sign as identifying your business, rather than just being a descriptive or generic indication. However, this requires a large number of years of use, and you need to be able to provide a lot of compelling evidence. So trying to prove acquired distinctiveness, as we call it, makes the application process a lot more time consuming and costly. And while there might be business appeal in having a trademark that indicates what the goods or services are or promotes their qualities, from a trademark perspective, it's advisable to use signs which are further removed. This is not only so that you can protect your brand against other businesses and obtain trademark rights, but from a commercial perspective, it can be beneficial to have trademarks that are more memorable for consumers and which stand out from other signs being used on the market. And that's so that you can more easily build up awareness of your brand and valuable goodwill among the public. So in summary, there's a lot to think about when selecting your trademarks and working out what precisely you should be trying to register.
Okay, so as well as thinking about the actual mark that you want to protect, you also need to consider what products or services should be covered by the application. And this is because trademarks don't give you sort of unlimited protection, but their scope is defined by what we call a specification, which is basically a list of goods and services that would be covered by the application. And so when deciding what goods and services you want to cover with the application, the starting point really is that you want to be protecting your trademark for all of the goods or services that you either use or intend to use your trademark for. So this is really because you can't add further goods or services to an application once it's been filed or to a trademark once it's been registered. And if you want to broaden your protection at a later stage, then you'd need to file a new application. So as a result, you may also want to think about trying to future-proof your protection by extending the coverage of the application to include perhaps additional goods or services that you reasonably see your business expanding into in the future. So a sort of general rule of thumb that we tend to use is sort of protecting anything that your business is doing now or imminently, but also what you might be looking to expand into within the next sort of 2 to 3 years. Because again, we do need to bear in mind that sort of five-year window I was talking about earlier. So if your trademark covers loads of goods and services that after 5 years you're not using the mark for, then it could become vulnerable to being cancelled. As a more practical point, you should also be aware that all products and services are categorized into 45 different classes. So this is really sort of an administrative device to help kind of streamline the application process. So provide some examples. Consumer electronics, so things such as cameras, smartphones, these typically fall within class 9. Vehicles belong in class 12. Furniture belongs in class 20. So, you know, it's all kind of categorized in different areas. And your trademark attorney would be able to prepare a list of goods and services classified accordingly for your approval prior to filing. The main thing to note about this class system is that the number of classes covered by the application has an impact on the overall filing cost. This is because the official fees payable to the Trademark Office and the legal service charges of your trademark attorney will increase according to the number of classes covered by the application. And so these cost implications mean that it might be necessary, particularly for brands whose goods and services fall across a number of classes, to be selective regarding the scope of an application in order to keep within a certain budget. So a good example here would be a clothing brand, because they might also offer sunglasses, jewelry and bags alongside clothes, but all of these fall within different classes. So you'd be looking to cover all of those things, you'd be looking at an application in 4 classes. And if the budget kind of doesn't allow for that, then you may need to focus on the particular products which are likely to be a kind of core of your business. So in this case, you might choose to proceed just with protection for clothing and bags. Again, a trademark attorney would be able to assist you in obtaining cost-effective coverage within any budgetary constraints that you might have. I think really the sort of main takeaway point from what we've just been talking about is that it's really important to spend time deciding exactly what trademarks you want to protect and for what goods and services before you commit to filing any applications. whilst to a certain extent, time is kind of the essence, because we talked about the UK being sort of first to file. I think it's really important to make sure that you kind of get everything in order before committing to filing that application, because this will ensure that your trademark portfolio can be kind of as streamlined and therefore as efficient as possible for your business going forwards.
So now that we've discussed what to register in terms of the marks and the goods or services, we should talk about where you should seek to register your trademarks. And trademarks are protected on a country-by-country basis. The law and practice and procedures vary from country to country. There isn't such a thing as a single worldwide trademark registration that you can obtain, and a trademark registration in a particular country generally only protects your mark in that specific country. So you need to think about the countries that you wish to register your trademarks in. Ideally, you would aim to register in all of the countries in which you foresee using your trademark. It's also worth considering protection in some other countries where your branded goods are perhaps manufactured, especially if this is a country such as China, where a lot of businesses encounter infringements and run into trademark difficulties, such as people knowingly registering well-known trademarks of overseas companies and effectively being kind of trademark squatters on the register. While the general position is that separate applications are required in each country of interest, there are some exceptions to this and ways of streamlining the process. For example, it's possible to register a trademark covering the whole of the EU by filing just one European Union trademark application with the European Union Intellectual Property Office. And this may be a lot cheaper than filing separate applications in particular EU countries of interest to you. There's also an international system that means that you can file one application with the World Intellectual Property Office, WIPO, specifying multiple particular countries in which you want to register your mark. Your application is ultimately examined by the trademark offices of each chosen country individually, which each decide whether or not to protect your mark in their country. And you eventually end up with a bundle of trademark rights in multiple countries of interest to you. This can work out a lot cheaper than filing separate applications in multiple countries directly. It's also possible to stagger your trademark applications by filing just one application for your trademark initially, and applications in further countries up to 6 months later, claiming what's called priority to the first application that you filed. Claiming priority means that your later applications share the same earlier filing date as the first trademark application you filed. And this can be important in terms of trying to ensure your applications are earlier than those of third parties, so that you ensure that you have the prevailing rights. It also helps you to spread the costs of filing trademark applications and buys you some time to consider your strategy for pursuing protection in additional countries. A trademark attorney can help you to devise a filing strategy for obtaining appropriate protection for your trademarks in as cost-effective a manner as possible, and talk you through all your various options.
So we've covered the various key issues and considerations to be taken into account when thinking about securing trademark protection. And we're now going to briefly outline the actual application procedure. This differs in each country, and so we're just going to be focusing on the UK. So fundamentally, you will obtain a trademark registration by filing an application form with the relevant trademark office. So in the UK, this is the United Kingdom Intellectual Property Office, or the UK IPO. Filing an application through Dehns for one mark in one class costs about £500. And as outlined previously, further classes would be additional. But as part of the process, we would advise you on some of the issues previously outlined, such as the format or formats in which you should seek to register your trademark and the filing strategy, as well as preparing the list of goods and services. Once the application is filed, the UK IPO will examine whether or not the application meets the formal and legal requirements for registration. So this includes issues like the accuracy of the classification and ensuring that the trademark is not descriptive, which is what Adam was talking about earlier. If the application doesn't meet the necessary criteria, then the UK IPO would raise an objection and will provide an opportunity for the applicant, usually via legal representatives, to take steps to try to overcome the objection. So for instance, this might be done by perhaps amending the list of goods and services, or by submitting arguments and evidence to try and change the UK IPO's mind. So for instance, if the UK IPO thought that your trademark was descriptive, you might have particular reasons as to why your trademark's original. So for example, if it's a play on words, or if there's something else about it that makes it memorable. And so, you can submit arguments in response to the UK IPO examiner to kind of put forward your case. And this is something we do quite often in response to objections.
And once any objections have been overcome, your application would be published for a period of 2 months, and third parties would have the opportunity to object to your application, for instance, if they have earlier trademark rights, by filing what we call oppositions. And if an opposition is filed, you and the opposing party enter into formal proceedings before the Trademark Office. And this involves both parties submitting arguments and evidence, and potentially at the end a hearing before the registry, who would then decide whether or not to uphold the opposition and refuse your trademark application, or whether they dismiss the opposition and allow your mark to be registered. Alternatively, you might be able to reach an amicable settlement with the opposing party. It would be fair to say that the majority of trademark conflicts are settled between the parties. One way of resolving an opposition could be by coming to an agreement that allows both businesses to use their marks in a way that would avoid or minimise commercial conflict in practice. For instance, the parties might agree to use their marks in different stylised ways to make them appear more distinguishable in practice, or they might use their respective marks in relation to different subcategories of goods or services, or in relation to different business sectors. To give you an example, if both parties were in the software market, one party could agree to only use its mark for banking software used for kind of financial purposes, and the other party could agree to only use its mark for software for photo editing. And therefore they would be kind of targeting different consumers, and the likelihood of confusion might be reduced. Settlement agreements like this are not uncommon, but they do come with a number of risks. It's always advisable to work with a trademark attorney when entering into these kind of arrangements. If no opposition is filed to your trademark application, or once any opposition has been successfully defended or has been settled, the Trademark Office will go on to register the trademark and issue a certificate of registration. For a straightforward trademark application in the UK that doesn't encounter any objections or oppositions or other issues, you could obtain your trademark registration within 4 months from filing your application. But it could take a lot longer than that if there are objections that need to be overcome or opposition proceedings are initiated. Registered trademarks are protected for 10 years in most countries, including the UK, and they can be renewed every 10 years indefinitely. In this way, trademarks differ from other forms of IP, such as patents, designs, and copyright, which are only valid for a certain limited time period. As long as you keep renewing your trademark registration and a third party doesn't manage to cancel it for any reason, then you can effectively keep your trademark registration forever. However, as touched on earlier by Alex, continued use of the trademark is vital in order to protect your registration from cancellation on the basis that you haven't used the mark, and to ensure that you can actually enforce your trademark registration against third parties. For example, if you have registered your mark in a particular stylized manner, and over time you come to use your mark stylized in a slightly different way, it's not uncommon for logos to change over time, you could find that another business could successfully attack your trademark registration and have it cancelled on the basis that you haven't been using it in the way it was registered. Additionally, after 5 years of having a registration, if you want to rely on that registration against someone who's infringing it or in an opposition to another person's trademark application, it's likely you'll be required to provide evidence that you've used your mark as registered for the goods or services it covers. Therefore, if there are changes to your branding or to the goods or services that you offer, you should always consult with your trademark attorney to see if any new trademark applications are required.
So this has obviously been a fairly whistle-stop tour of the function, the importance and the practicalities of trademarks in the UK. But we do hope that it's provided some insight as to the types of things that business owners should be thinking about, both prior to launching and also throughout the life of the business. We obviously appreciate that in the current sort of climate of uncertainty caused by COVID-19 and also the economic strain the lockdowns have had on businesses, then it's sort of inevitable that IP budgets are going to be kind of squeezed and scaled back. However, we just want to make the point really that now, just as ever, trademarks really will continue to be an important business asset, which will help to establish your brand's reputation and distinctiveness in the marketplace, thereby ensuring that you can retain custom for the continued success of your business going forwards. To kind of illustrate this point, the European Patent Office and the European Intellectual Property Office have commissioned a report which was published in September 2019, and it found that industries and businesses that were what they call trademark intensive, so basically those that kind of really make use of and exploit their trademarks, especially companies that are involved in kind of manufacturing or business services, it found that these businesses made a really significant contribution in terms of both employment and also economic output. More interestingly, actually, the 2016 version of this study, which looked at data relating to 2011 to 2013, during which time much of Europe was experiencing a financial crisis, this study found that those within sectors which were making use of intellectual property actually coped far better with the difficult conditions compared to the rest of the economy.
And to add to what Alex has said, at times of uncertainty and distraction, counterfeiters can really exploit those moments in time. And that means that it may now be all the more important to be vigilant and to protect your brand as strongly as you can. And as a practical point, you might also think about ways your business has changed during the current crisis and whether any protection that you already have is still sufficient. For example, if you have trademark protection for cafe or restaurant services, but during this time you've diversified into offering pre-prepared meals for consumers to purchase and enjoy at home, then it might be that you need to look at your existing protection and see if any additional protection is advisable. Clearly, the current crisis raises many issues for businesses across all areas. We'd be more than happy to discuss these with you if you have any trademark-related concerns at this time. But for now, we'll address the questions that have been submitted during the webinar. So we have a question here. It says that we mentioned differences between countries and has asked if we can give any examples. That's a good question. So in the UK, the office will examine whether the mark itself is registrable, and it will draw up a search report of marks that it thinks, of earlier marks that it thinks might conflict with your trademark, but it won't itself refuse your application if on that basis. It would leave it for the owner of an earlier registration to file an opposition. Whereas in other countries, they actually will look for earlier trademarks, and if they think there's a conflict, they might raise that as an official objection and block registration of your mark on that basis without waiting for an opposition to be filed. Another example, in America, in the USA, when you want to file a trademark application, you have to rely on a particular filing basis, and this can include a foreign registration, intention to use the mark in the USA, or actual use in the USA. And if you rely on a use-based filing basis, then you actually have to file evidence of use before they will let you receive a registration. And as a third example, in China, Alex talked earlier about classes of goods and services. In China, they actually have a a system of subclasses within those classes. And that's important in terms of deciding whether particular goods or services are considered similar. So you have to kind of think about which subclasses you want to file in China. And all these things are things that we would advise you on if you were seeking protection in different countries. And when seeking protection in countries outside the UK, we would work with local attorneys who are specialists in their areas of law, and we'd be able to advise you accordingly.
Okay, so we've got another question here, which is about whether or not it's necessary to kind of register your trademark in the same way in every country. Okay, so this is a good question, because obviously loads of businesses do now trade overseas. This has obviously been made a lot easier by kind of the internet and how kind of easy it is now to sort of trade across borders. And so, yeah, I mean, often there are sort of issues to be taken into account here. So kind of as the sort of basic answer is not at all. You can register trademarks, different trademarks in different countries. As Adam mentioned earlier, trademarks are fundamentally sort of territorial in their nature. So you register a trademark in one country, you register it in another country, and so on. So it's perfectly possible to register different trademarks in different countries. So and this becomes particularly important in countries such as China, for example, where you might want to sell your product with the name in Chinese characters rather than the English version. And so you could always sort of register the mark in that form in China. Also, some brands might offer slightly different products depending on which country they're selling to, because of sort of various like regulations or requirements that they need to comply with. And so again, like you might need to protect your trademark for different lists of goods and services. And again, this is something that's perfectly possible. I think really the sort of main exception to this rule to be aware of is that if you want to rely on the sort of priority mechanism that Adam touched on earlier, in order to be able to file an application in one country and then file another application elsewhere within that six month window, the second application has to be identical to the first. So it needs to be filed in the name of the same applicant. The trademark needs to be the same, and the scope of the goods and services either needs to be the same or narrower. In order for you to claim priority. So in those circumstances, yes, your trademarks do need to be the same, but otherwise, no, you're free to sort of apply for, whatever mark that you want to in each country. Okay, so I think that's all the questions that we've had. If you do have any, other questions, please do get in touch with us afterwards. Thanks a lot for your time this afternoon. We hope that you found this session useful. Our contact details are on the screen now, so that if you do want to get in touch with us about anything we've discussed today, or if you want to seek advice on any particular topic or trademark requirements that you may have, please do get in touch with us. But for now, we'll pass back to Michelle, who will let you know about the future sessions that are being hosted by Dehns, which might be of interest to you, as well as our recently launched podcast series.
Hi everyone, thanks for joining us today, and thank you to Alex and Adam for presenting. We are running a whole series of webinars throughout the summer, and our upcoming ones are an introduction to IP, freedom to operate, that's on the 20th of August, and then AI and patenting AI inventions on the 27th of August. You can register for these on our website, and some links will also be in the follow-up email to this webinar. As Alex mentioned, we've also launched a podcast. It's the IP podcast, and it's a 15-minute jargon-free look at various different aspects of IP. You can find that by searching for Dehns on Spotify, Apple Podcasts, and Google Podcasts. But we will also send you a link to that in our follow-up email. And if there's anything you'd like us to cover in future webinars, just let us know and we'll see if we can accommodate that. But otherwise, we will see you at another webinar soon. Thanks, everyone. Thanks, Alex. Thanks, Adam.